Today we are going to discuss fundamental rights. Why they are called fundamental rights? Why they are called fundamental? They are called fundamental because they are required for the overall development of a human being, whether it may be morally, physically, mentally, and intellectually. Rights can be classified into different sets. These are natural rights, human rights, fundamental rights, constitutional right, and statutory rights. Natural rights. Natural rights are those rights which has been given to all the living creature by nature. Human rights. Human rights and natural rights are often same, but there is some exception. Human rights are provided only to the human being. Constitutional rights. Constitutional rights are those rights which are guaranteed by constitution to the people of a country. In case of India, Article 326. Article 326 says that any person who is 18 or above and are not disqualified by any law made by parliament have right to vote in election. And this whole scheme of thing is called universal adult franchisee. The last set of right is statutory rights. These rights are provided to the people by various laws passed by the legislature. Example, National Food Security Act and Manrega, MG Fundamental rights are given in the Part 3 of the Constitution. These rights are justiciable in nature, which means for the violation of fundamental rights, we can directly approach to High Court or Supreme Court under Article 32 and Article 226 of the Indian Constitution. Fundamental rights are restriction and limitation on government action. Thus, government cannot take any action, administration, whether it may be administrative, legislative, or punitive, by which any fundamental right is infringed. Infringement means that the guaranteed right under Part 3 of the Constitution cannot be taken by ordinary law, and such law curtailing any fundamental right would be declared unconstitutional and on judicial review, which means Parliament can amend fundamental right, but it cannot amend fundamental right by ordinary bill. It can amend fundamental right by constitutional amendment bill, and it can only amend those part of fundamental right by constitutional amendment bill which has not been declared as basic structure by the Supreme Court. What is basic structure? Basic structure are those provisions of constitution which are very important for the functioning of the constitution to hold the ideals of constitution, and such provisions are declared as basic structure by Supreme Court. If that provisions are removed from the constitution will lose its essence and importance. So any law which is against the fundamental right or which is against the basic structure will be declared as null and void by Supreme Court under judicial review. What is judicial review? Judicial review is the power of judiciary to declare any law or executive action as null and void if it goes against the provision of the Constitution. Fundamental rights are not absolute in nature. That means there is limitation upon fundamental right. Fundamental rights can be suspended during emergency except Article 20 and 21. There are certain other limitations which has been put by Constitution on fundamental rights. These ground of restrictions are sovereignty and integrity of India, the security of the state, friendly relation with foreign state, public order, decency or morality, or in relation to contempt of court, defamation or incitement to an offense. There are 6 set of fundamental rights. Right to equality from Article 14 to 18, right to freedom, Article 19 to Article 22, right against exploitation, Article 23 and 24, right to freedom of religion, Article 25 to 28, cultural and educational right, Article 29, Article 30, right to constitutional remedies, Article 32 to Article 35. Fundamental rights start from Article 12 and goes till Article 35. What does Article 12 says? Article 12 basically consists the definition of a state. Article 12 says that the state include government and parliament of India, government and legislature of a state, All local or state authorities such as municipalities, panchayat, district board, improvement trust within the territory of India or under the control of government of India. That means government of India and parliament, government of all the state and all the state legislature or any other board such as municipality, panchayat, trust and any other organization. But according to Supreme Court, any company or any institution which is receiving aid from the state shall also be a part of the state, in which Supreme Court says that the concept of agency or instrumentality of the government is not limited to a corporation created by statute but is equally applicable to company or society such as ONGC, GAIL. Article 13. Law inconsistent with fundamental right and judicial review. As I have said that if Parliament passes any law which takes away the fundamental rights of people, it will be declared as null and void by judiciary. Article 13 gives teeth to the fundamental right. If Article 13 would not have been there, the government might have taken away the fundamental right and we will not be able to go to court for their enforcement. So Article 13 gives teeth to the fundamental right. Article 13 clause 1 says that all pre-constitutional law shall be void to the extent of their inconsistency with fundamental rights. Article 13 clause 2 says that states shall not make any law which take away or abridges the fundamental right, and any law made by the state contravening any fundamental right shall to the extent of such inconsistency be void. This provision deals with post-constitutional law. Article 13 empowers judiciary, especially the Supreme Court, to act as a guardian, protector and final interpreter of fundamental rights. Supreme Court has also said that judicial review is the basic feature of the Constitution. Parliament cannot curtail the power of judicial review by passing any legislation or through any constitutional amendment, which means if tomorrow Parliament passes any amendment bill and tries to take away the power of judicial review from judiciary, it will be declared null and void by judiciary, because Article 13 itself says that power of judicial review is a basic structure of constitution and parliament cannot amend the basic structure of constitution, as Supreme Court said in Keswanand Bharti versus State of Kerala case. Right to equality. This is the first set of fundamental rights from Article 14 to Article 18. Article 14 says that states shall not deny to any person equality before the law or equal protection of the law within territory of India. Equality before the law means you may be so high but law is above you. No one is above the law. Equal protection of law means everyone is subjected to same ordinary law code guided by same ordinary law of the land in equal manner. There shall not be any kind of discrimination. Article 14 is available to any person including legal person, corporation and company, which means Article 14 is available to citizen as well as foreigner. Article 14 is taken from the concept of equal protection from USA. The concept of rule of law is a negative, while the concept of equal protection of law is a positive concept. That means by rule of law, Parliament can take the life and fundamental rights of people, which is a negative connotation. But equal protection of the law means every person, whether rich or poor, shall be subjected to same law code guided by same ordinary law of the land without any discrimination, which is a positive connotation. The concept of equality before the law is equivalent to second element of concept of rule of law, which has been given by Dicey, who was a British jurist, and there are certain exceptions such as President of India, State Governor, public servant, judge and foreign diplomats who enjoy immunity, protection and special privilege. Now another article is Article 15. Article 15 mainly talks about prohibition of discrimination. Article 15 says that Constitution prohibits discrimination against any citizen. That means this article is available only to citizen, not to foreigner, on the ground of race, religion, caste, sex and place of birth. These are grounds which are mentioned in Constitution. However, as per Article 15 clause 4, government may by special provision make for the advancement of any socially and educationally backward class of citizen or for scheduled caste and scheduled tribe. That means if government feels that any class of citizen, whether they are socially or educationally backward or whether they are scheduled caste and scheduled tribe, they have left behind the race of development, state can make special provision for them. This is a exception to article 15. Article 15 clause 5 provides that state may make law for the advancement of any socially and educationally backward class of citizen for the scheduled caste or scheduled tribe in the admission to educational institution, whether private or government, which has receiving fund from the state, but it cannot make law for the reservation of seat to such class of citizen to minority educational institution. Constitution 103rd Amendment Act 2019 has added a new provision, that is Article 15 Clause 6, which says that state can make any special provision for economically weaker section EWS category, and it also says that state can make any special provision for the advancement of economically weaker section of citizen and for their admission to educational institution including private educational institution whether aided or unaided by the state. However, such reservation will not apply to minority educational institution. This is exception. Reservation to such educational institution would be in addition to existing reservation and subject to a maximum of 10%. That is, already there is 50% reservation and there will be additional 10% reservation. So total reservation will be 60%. This is 10%. According to Supreme Court, the reservation shall not exceed above 50%, which has been given in the verdict of Indra Sawhney case. But Supreme Court has also said that in special circumstances, state may breach this upper limit cap and provide some extra reservation. So this is 60%. Now, Article 16. Article 16 basically prohibit discrimination in employment in any government office. There shall not be discrimination in employment to any government office. Article 16 clause 4 says that state may make any special provision for the reservation of appointment or post in favor of any backward class of citizen which in the opinion of state is not adequately represented in the service under the state. If state feels that any class of citizen, whether it is socially, educationally, scheduled caste or scheduled tribe, if state thinks that this class of citizen has left behind and they have not been given adequate representation in the office of government, state may make special provision for their reservation of seat the government office and providing the place of residence as a criteria for appointment to the office of government in the state. The Constitution 103rd Amendment Act 2019 has given a new provision, Article 16 Clause 6, where the state may make any provision for the reservation of appointment or post in favor of any economically weaker section of citizen in addition to the existing 10% reservation. That means state can make reservation for the appointment to the public office for economically weaker section and that shall be 10%. The reservation for up to 10% for economically weaker section in educational institution and public employment will be in addition to existing reservation. This is the same case. Already there have been 50% seat reserved. There will be additional 10% seat reserved for economically weaker section. So total percent of seat reserved in the state is 60%. Article 17. In the first slide, I have said that fundamental rights are not absolute in nature, but Article 17 is an exception. Article 17 is absolute in nature. That means there is no restriction upon Article 17. Article 17 says that untouchability is abolished and its practice in any form is forbidden. The enforcement of any disability arising out of untouchability shall be an offence punishable by law, which means that any person, whether a private individual or any public official, if it practice the policy of untouchability, that is a compoundable offence and that offence shall be punishable by the law. Article 18 talks about abolition of titles. In the earlier times, we have heard about the titles such as Jamindars. Article 18 says that no title except military and academic distinction shall be conferred by the state. No citizen of India shall accept any title from any foreign state. It says that no citizen of India shall attach to their name any title except military or academic which has been given by the state, and Indian citizens are also not allowed to accept the titles from the foreign. People cannot attach their name to titles such as Jamindar XYZ. No, this is wrong. This is prohibited by the constitution. The awards such as Bharat Ratna, Padma Vibhushan, Padma Bhushan, Padma Shri, called as national award, would not amount to title within the meaning of Article 18. These are the award, not title. So, a person can keep Bharat Ratna ABC, Bharat Ratna XYZ, Padma Vibhushan ABC. So this can be kept, but one cannot keep Jamindar ABC, Jamindar XYZ. This keeping of title has been prohibited by the constitution. Only those titles could be attached with the name which are military or academic, and that has been confirmed by the state. So in this video we have seen what are fundamental rights, why they are called fundamental rights, what is the basic feature of fundamental rights, and the first set of fundamental rights, that is Article 14. Article 14 talks about equality before the law and equal protection of the law. Article 15 talks about prohibition of discrimination on the ground only of religion, race, caste, sex and place of birth. Article 16 talks about prohibition of discrimination in case of employment to public office. Article 17 talks about abolition of untouchability. Article 18 talks about abolition of titles. So in this first video we have discussed the first set of fundamental rights, and in coming videos I will discuss another set of fundamental rights and further article and their provision in the constitution. Till then, goodbye. Thank you.